This is Committable. I'm Jesse Mangan, and for this episode, we're talking about protection and advocacy organizations. And we're very lucky to have with us here Mark Joyce from Disability Rights Maine. Mark, do you want to introduce yourself? Say whatever you want about who you are and the type of work you do.
Sure. My name is Mark Joyce. I am a managing attorney and a program director for the Protection and Advocacy for Individuals with Mental Illness, or PAMI program at Disability Rights Maine. Disability Rights Maine is Maine's protection advocacy organization designated by the state, and I've been an attorney here for 24 years. I practice exclusively in the area of mental health law. Although Disability Rights Maine, we have a number of different grants we operate under, and the other, because there are a number of grants under the protection advocacy umbrella, and I can talk about that a little more. But my focus primarily is mental health.
And I think the general public might not fully understand what a protection and advocacy organization is. So, what is a protection and advocacy organization?
For the younger folks, they may not remember this way back when, but the Geraldo Rivera was in the 70s. He was an investigative reporter. And so there were complaints or people talking about how individuals with developmental disabilities were being treated at the Willowbrook School in New York. And so he had his team go in there, and they were not, invited in. They got in, and they were able to take these horrific, and I mean horrific, videos of how people were being treated and living. And you can see those, I believe, on the National Disability Rights Network website. There is a link to that particular video, that particular story, and it's I would just say to anyone who's going to watch it, be aware that it's very jarring. So you may just be aware of that ahead of time. And after that particular expose, Congress began hearings, and essentially what they determined was that states left to their own devices can't protect the rights of individuals, at the time, individuals with developmental disabilities, in a way that the federal government was very okay with because of the lack of certain systems. So they developed what's called a protection and advocacy system. And the first part of that was the Developmental Disabilities Act, and that was in 1977. They tied it to the receipt of Medicaid money. And so if states want to get certain Medicaid money or certain funds, they had to have a designated protection advocacy organization in their state. That has since expanded, and I can talk a little more about the Protection Advocacy Organization, the PAMI Act. So that expanded to then include in 1986 individuals with mental illness or psychiatric labels. It's called Protection Advocacy for Individuals with Mental Illness. So I'll use that term because that's what it says in the statute, although I like to use the term psychiatric labels or psychiatric disabilities. And I can talk more about that if you want me to, in terms of the hearings regarding that focused on that population. And so another statute was passed. And what these statutes do is they don't just give funding, they give the organizations that are designated as protection advocacy organizations a lot of statutory authority to have access to facilities and places where people with disabilities are found, particularly overnight facilities that are providing treatment, so that the services that are provided, you can't stop someone from going into a psychiatric hospital because the law requires it. And I think that's really important. So, for example, in the Protection and Advocacy Organization for PAMI, which was taken after PAD. It's called PAD, Protection Advocacy for Developmental Disabilities, and then PAMI. And then there's another one that's called PAIR, which is Protection Advocacy for Individual Rights, which is a much smaller grant, and it's for people who don't fall in the rubric of the PAMI or the PAD, say somebody who has a physical disability. And then we also have a PABS, Protection Advocacy for Beneficiaries of Social Security. So there's a number of different grants that all come in within the rubric of protection advocacy organizations. The charge for the PAMI program and for the PAD program is, and I printed this out because I think it encapsulates, like people say, what are you supposed to do? What do you do? What do you guys do? So the purpose of it for the PAMI Act, which along with the PAD, it's almost the same thing, is to, and this is in the statute, to ensure that the rights of individuals with mental illness are protected, to protect and advocate for the rights of such individuals through activities to ensure the enforcement of the Constitution and federal and state statutes, to investigate incidents of abuse and neglect of individuals with mental illness if the incidents are reported to the system or if there is probable cause to believe that the incidents occurred. And within that rubric, under the regulations that were passed, they have about 6 sort of sections to talk about what other activities are expected that the P&As can do. So the statute and I won't cite the statute and regulations, but these all come from these statutes and regulations, is individual representation, systemic activities, monitoring investigation, providing information and referral, outreach, educating policy makers, and training. So one of the key things in the PAIMI statute is the requirement that you have what's called a PAC, or a PAIMI Advisory Council. And that council advises, like DRM, it advises the Protection and Advocacy Organization on what type of priorities the organization should have. And a lot of the work is around priorities, because under the statute and regulations, you have to develop a set of priorities to inform, and each community is different, right? And so, and it's to inform the how the your P&A should, do their job. And what's great about the PAC is that it has to be 60% of individuals with lived experience, mental illness. That's what the term in the statute. I just want to make sure this isn't my term. Okay. There are also requirements to have a person who has a family member, it was a child on the PAC and on the PAC. Also, an individual has to be a lawyer, a mental health professional, but 60%. And the reason behind that was that when these statutes were being passed, there was real concern that there wouldn't be a consumer voice tied to the organizations that are getting the funding to do this work. And so they created the PAC. And so we work closely, and the PAC works closely with the P. They're part of our organization because of the statute, but they are independent. Like, for example, every year they submit on their own to SAMHSA and I have nothing to do with this, an assessment of our P&A and how they think we're doing. And so that's sort of one of the priorities, and each P&A has different priorities. So like for Maine, we have a priority of abuse, neglect, rights violations, community inclusion, housing, and education. And so one of the things that we really rely heavily on the PAC for is we have such limited funding. Our grants have been flat funded or close to it for years. But the need for our services has just grown exponentially. And so we really have to make these sorts of like determinations as to what kind of cases we're going to take, and then make the real hard decisions about how much resources for this case. If you did this, what case couldn't you take? And those are tough conversations to have. And so we have those conversations with the PAC, right? We have that conversation with like, here are our priorities. Do you think these priorities are reflective of what the community is? We meet with the PAC often. Any PAC member can call me up at any time. Talk about like what's going on in your community. What do you think we should be doing? What sort of things? And then we have the conversation back and forth about like, okay, what's that going to look like given the limited resources?
It's an incredibly sort of distinct combination of experiences that you're describing for a PAC. But someone with legal experience, someone with clinical experience, family member of someone with going through the systems, and then the 60% lived experience. So drawing on those insights, working in Maine, what sort of projects are you focusing on with education and with focusing on community involvement?
One of the things that, and this happened, and this shows the how we work together, is that one of the big issues that they identified and that we all identified is the issue of being stuck in emergency rooms. Okay. So that was, look, Mark, that's a big issue. What are we going to do about it? So a couple of years ago, found a case. You can't just sit around waiting on the phone to ring them. You gotta go out. So we have people who go out all the time. They are out in the community all the time, right? So you'd be surprised at how many different nuanced sort of issues. And the issues become one where if you can fix it here, it's not going to turn into this thing over there. So we do a lot of that. But the emergency department one, so we found a woman who had been in the ED for 65 days. She had been there under what's called in Maine the emergency and voluntary commitment hold, where you're only supposed to stay for 24 hours and then go to be admitted to a psychiatric hospital. The problem is the statute allows the psychiatric hospitals to refuse the individual. There's no wait list. There's a problem with the statute. This is a separate thing. There's a real problem with the statute. In any event, so we found the woman. We tried to work to get her out, because we don't sue right away. One of the things is that because we don't have the resources to immediately sue right away. So we tried to figure out something, didn't work. So on day 65, we found her like probably day 50, whatever. I mean, it wasn't that, I mean, it was day 60. So it was like, come on, what are we going to do here? So we filed a writ of habeas corpus, and she was released that next day, right? Not released, but she still met the criteria for involuntary commitment, right? For the emergency, but she can't have a hearing. This is the problem. She can't have a hearing until she gets kicked out of there and she goes to the psychiatric hospital, which then files for the commitment, which then allows you to have a hearing. You could be stuck indefinitely without a hearing in the emergency room the way the statute's written. So when she finally got out, went to the psychiatric hospital, discharged back to her apartment, okay, where she'd been living for years. The hospital said, "Well, it's all moot. Laura, we don't have to go through that." And I said, "No, no, 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 no. We need a judge to look in this." The judge agreed. We have a full hearing. Her testimony was like it was. She testified about how it felt to do what happened, and the court was like this. The legislature and the executive should do something about this because the court can't do this because of the way the statute's written. So a bill was submitted this past session to at least start the process of addressing some of the things that were and I wrote a blog, I'll send you the blog with the case, some of these things that were talked about in the case. It got voted, and you can see on the website who objected to it, all of this testimony, because it's all public record. It didn't get out of committee, right? But members of the PAC testified at the hearing, right? Because this is a priority, this ED. So like, were there people who called on other issues in the community whose cases we couldn't take because we were working on getting this case done for the habeas and then the trial and everything? You bet, we just can't do everything. But when we make those decisions, you look at what's going on with that versus, and I tell people because they call me and they say, "Mark, why can't you take my case?" And I say, it's not because you don't have a legitimate beef. Everyone who calls me has a legitimate issue. It's just the resources we have to deal with these things. We have to make these tough decisions, and the PAC, because they're the ones with the lived experience, they're the ones in the community. That really helps, not just make the priorities, but also have the conversation about how we effectuate the priorities given our limited resources.
So in Maine, the involuntary hospitalization process works. Someone might get picked up by police and brought to an ED. I assume there's a petition process. Maybe someone's brought in, maybe a doctor initiates it. Is that called a blue paper?
Yeah, so it's extremely easy.
Okay.
I don't want to say easy, but the process. So the process is that a police officer can go ahead and pick you up if there's probable cause to believe you have a mental illness and that you pose a likelihood of serious harm. And posing the likelihood of serious harm, the way that it's defined, is that it can also be if you can't take care of yourself to a certain, I mean, there's that, it's not just suicidal, homicidal, it's that sort of, you can't take care of yourself. And this is the probable cause can be, it says, if a law enforcement officer has probable cause to believe that a person may be mentally ill and that due to that condition, the person poses a likelihood of serious harm, they can take them into protective custody. Now, when formulating the problem, this is in the statute, right? When formulating the probable cause, law enforcement officer may rely upon information provided by a third-party informant if the officer confirms that the informant has reason to believe, based upon the informant's reasonable personal observations or conversations with the person, that the person may be mentally ill and due to that condition, the person poses a likelihood of serious harm. So it's not a high bar. Then they get taken to the emergency department where it's a one sheet of paper and it's called a application for emergency admission to a psychiatric hospital. They're not being admitted to the emergency. It's the application to start the process to get to the psychiatric hospital, where that's where the emergency admission is. And within like 3 days, they have to decide whether or not, or 5 days, they have to decide whether or not to file a petition for commitment, which triggers your right to a hearing, right? So if you're in the ED, you've got no right to a hearing. And what has happened is that because what people they'll have the first part is someone can write out anyone. I could write out anybody. I mean anyone. It doesn't have to be a social worker. But usually it's the crisis person who works at the ED or a crisis person says, yeah, I believe they meet the standard. Then a physician or a licensed nurse or anyone who's a provider in the statute can check box it off. Then the third part is that it has to go to a judicial officer, not for a hearing, just to make sure the boxes have been checked, okay? And that they have to then sign off on the person being sent to the psychiatric hospital so the process can start where you get a hearing, right? Or released, because if you get up there, there's a 24-hour certification process where if you're up there, they don't admit you until you have a psychiatrist or a psychologist, really a psychiatrist who determines that, oh, okay, this is correct. The blue paper is correct. We're going to admit them. And then they have the time to file for the commitment, but if they don't, the person's got to be released. And when they do, that triggers the whole timing. The problem is that when the ED calls these various psychiatric hospitals to see if they'll take the person, they can just say no. Due to our milieu, we think the person's too acute, and they can take the person sitting next to them who just got there, which would happen to my client. And the statute allows that. And so when there's no place to put where the person goes, the judge can't, the judicial officer, which can be a justice of the peace, has no place to send the person. So then what happens is the statute changed to allow two 48-hour extensions. And the second 48-hour extension, you had to tell the Department of Health and Human Services, hey, there's a person stuck here. But they still don't have the power to force anyone to take the person. So what, right? And so the judge, when I sent you the blog and the decision, the judge said, look, there's nothing that no one can do here. The legislature's got to step in, or the executive. And so this is the judge, but the judge did say in the decision that a person stuck like that does have a right to a court-appointed lawyer, which was a good. But again, you can file the habeas, but unless a psychiatric hospital is going to take the person, they're still going to meet the criteria. No one's going to release a person if they believe they meet the statutory criteria for commitment and pose a likelihood of serious harm. They're just not. And that's really where that person gets stuck.
So one of the things that strikes me about that whole process is it initiates with a probable cause sort of standard. And that probable cause from someone who may have no training in mental health related work, or a police officer, anyone, they use that probable cause standard. Someone gets caught in an ED, and then they assess in a moment. They're assessing a moment in time. They're saying, in this moment in time, we believe there is probable cause, a reasonable belief that you may be dangerous in some way. That can express in different ways. But I guess one of the things I struggle with in trying to understand these systems is my understanding of the federal precedent, the civil commitments at least, it's a clear and convincing evidence standard. So when you're talking about the deprivation of someone's rights for any long-term period of time, it should be clear and convincing standard. But it's like a workaround. Workaround is the wrong word, but this feels like a hole in the legislation that allows a probable cause standard to lead to long-term detention. And I'm assuming they're not really getting any meaningful sort of engagement with treatment while you're in an emergency department, right?
One of the reasons we got involved was because the charge nurse at the ED called us.
Oh, wow.
And she testified at the hearing, and she said, "This place, there's zero." She says it's 100% security, zero treatment. This person needs to get out of here because what they would do is they would just say it's acuity or milieu. There wouldn't be any reason. So part of the statute, the part of the bill that was presented was to force these hospitals to give us, and including the state hospitals, both the private and state hospitals, to give a specific reason as to why you can't take this person and what you would need to have that change to take them. Because they were just saying, oh, it's milieu, it's acuity. And so your point is right. I mean, this the statute, as I mean, it does allow, it's got some constitutional infirmities for sure, because when you get to your hearing to get to that clear and convincing when you're at the commitment hearing. But the only way you can get there is you've got to get out of the ED because they can't file for commitment in the ED. And so you have to get to the psychiatric hospital, which then triggers their responsibility to file for commitment to get you that hearing that has the clear and convincing standard. And if they don't file within a certain amount of days, you get released. So as long as you stay in the ED, you're in this zone of potential and it's indefinite commitment, and not even commitment is because one of the things at the hearing, and she made a very good point. She says, "Well, can't we just have the commitment hearing here?" I said, "No, because of the fact that the commitment hearing requires there be a treatment plan submitted that the judge looks at to determine whether or not it's a good enough treatment plan to show that the person, that they meet the standard." And so because the nurse talked about there's zero treatment here, you could never be able to have a treatment plan submitted while the person's in the ED because there's no treatment given. So that wouldn't work. So you can't even have the commitment hearing there. It's a really big problem. And so this is one of the things to tell you, one of the big things we're focused on is this particular issue because of the way the statute allows for the hospitals to, it's not the hospital's fault. I mean, they're just exercising their right. They're saying, yeah, we have the right not to take the person, don't want to take them. Don't want to give you any reason. And they're right.
Well, I assume for the hospital, it's also they're caught in a liability trap where they may not want to take that person for whatever reason, but if they just release that person, there's a liability question, right?
Oh, well, for the ED.
Oh, for the ED. Oh, right. Yeah.
Yeah, I'd imagine for the ED, for the admitting hospitals, because the state they contract with the state, they're given tort claim immunity for people that they take. So they're given this immunity, and the contracts, and you'll see in the decision, the contracts with the state have the hole where they allow them to still not take the person. And so anyway, so that just shows like when you say which kind of cases do we look at and take when I talked to the PAC about this, oh yeah, we need to take this one because it meets our priority of abuse, neglect, rights violation. And then we do the ones that prevent people from, you know, I have a real philosophical bent on the way that you make sure no abuse, neglect, or rights violation happens in the ED or the psychiatric hospital. Is don't find yourself in there to begin with. And that if you have the housing and the services and the crisis services and these things available to you, if you have a home, you're not going to find yourself half as many times interacting with law enforcement. If you're homeless, you're going to be meeting there, and so just that interaction can trigger this. So we do also a lot of like making sure people keep their homes, getting the services and the crisis services. So it's a bunch of different things.
So the PAC, the advisory council, can establish these priorities. You work with them. They identify this case, which seems very obvious. The judge seems to agree, like this is a problem. Legislation needs to fix it. Someone drafts a bill, it doesn't get out of committee, which is obviously deeply concerning. So then do you switch to an education sort of platform? Are you trying to educate legislators on why this needs to happen?
Well, that's what we try to do in this particular. I mean, I submitted my blog. I submitted all this stuff. But I guess at this point, I mean, if we had another case like this, I may look to do a different thing, right? I may look to challenge the statute as unconstitutional. I mean, because it kind of is, in my opinion, because it allows for no one, and no one has told me, no one's come out and said, no, Mark, we can read it differently. I mean, it seems to allow for indefinite detention without a hearing. Now, the person can file for a habeas, but like I just said, the habeas isn't going to get you to the psychiatric hospital. And so if you can't get to the psychiatric hospital, because the habeas would work if the person didn't meet the criteria. But if they meet the criteria, they're not getting released.
Does the statute require some sort of periodic review when?
No.
Okay.
And the court, there was one case that this was brought up where the law court had said that, okay, you can do one more 48-hour thing, right? But they didn't say if there was going to be a limit. With my client, they did, because you have to fill out one more. The review is 48 hours happens. We're going to do it again. Okay, it has to go before a judicial officer again to take a look at. They sign off on it because there's still no place for them to go. So just for the judicial officer looking at it, they have no power. They have no authority to do anything. So in my case, there was 8 of these things. 8. Okay. 8, because you're there 65 days, right? So you've got, or 10, whatever it was. So it just kept on going. It just kept on repeating and repeating. And so, yeah, the review just kept on repeating. So there's a review, but it's just a sign off, because until you have the hospital that has to take the person. And she testified that there were people coming in and out of the emergency department who got picked and went ahead of her all the time because they got picked.
So with housing and working on community supports, because I know resources are always a problem with housing, is the focus to just try to get more resources, or are there discrimination type practices in Maine that require your attention?
Housing is one of our priorities because I really believe that housing prevents a lot of the bad stuff from happening by the person not finding themselves in these situations. So one of the Fair Housing Act and the Maine Human Rights Act are really powerful tools because of the reasonable accommodation provisions in them. So I'll give you a perfect example. You'll find sometimes that people are evicted or from their housing. They find themselves in the psychiatric hospital because of the lease violations. There's a nexus between their symptomology and the lease violations, and so you can ask for a reasonable accommodation. And the accommodation can be to rescind the eviction and allow the person to go back home and stay. I've done a number of those for people who were served with eviction in the psychiatric hospital. And so this one woman, so this just shows you there's such a disconnect between what people hear that's available and the process you have to go through to get what they say you're supposed to deserve. And we spent a lot, and I mean a lot of time on, like, for this lady. So she was eligible for a certain service that would provide in-home supports, that would provide these things under Maine Care regulations. Okay. She had been denied it because she didn't have the right paperwork. Because you need to have like a sign off on a doctor with a note saying, I mean, there's a whole litany of things for these things. So we had to file this appeal to get the services, to then say to the landlord, look, with these services, she is going to be able to address the behaviors that were due to her disability and comply with her lease. And one of the things I always tell people, because everyone says, well, she's getting a special treatment, she's doing this. Like, no, no, no. The law, the fair housing law, basically what it says is that you are given a reasonable accommodation to be able to enjoy your housing to the same extent as a person without a disability. So the law recognizes that individuals with disabilities will need these sorts of accommodations, not for a step up, not for special treatment, but so they can enjoy their housing to the same extent you do. And people have a hard time understanding that when it comes to mental health. When it comes to like physical disabilities, it's like, well, if you give a person a parking space and right and you waive that first come first serve, but you give a person a parking space because if they have to park way down by the other side of the road, they're not going to be able to enjoy their house like you enjoy your house because by the time they get there, they're going to be wiped out or maybe even injured. So you're not giving them a special treatment. They have to prove they have the disability because that's the law. And then you do the analysis of whether or not this accommodation is reasonable, which it is. And they think, oh yeah. So the person's able to go to the elevator, go up to their apartment and sit there and watch TV or do whatever they want, just like I am. That's not special treatment. That's equal treatment. And so, but when you're talking about somebody who might have yelled at somebody or done something, right? It's like, oh, well, they should get no, this shouldn't apply to them. But it does. And I can't tell you how many of my 20 some odd years here that I have gotten individuals we've saved their housing because of this process. It's just amazing to me sometimes how people will be like, well, they got to do this. Like, well, you don't do that. In your life, man. You've had help, you've had bumps, and you've gotten through. Why? The law sometimes is not as hard as the perception of people who don't want to follow the law. So,
So something I've heard about in another state is someone working with an ACT team, working with an outpatient commitment team, coordinating with a landlord so that when a person is brought to a facility, even if it's just temporary, the landlord can trigger an eviction because of the length of time the person might be away. Have you ever heard of situations where maybe a landlord is involved in a person being sent to a facility or even just brought into an ED or something like that?
well, I've never heard of that. In terms of the confidentiality for one thing, but so it's like if the person is on a progressive treatment program, right, and they have something where if they don't follow a certain thing, they're going to be in violation of their progressive treatment program, which is outpatient commitment, and they're going to be brought to the ED. In Maine, I don't know how states, in Maine, you cannot evict someone unless you go through the legal process. You've got to go through the legal process. So there can't be an automatic eviction. Now, a person can sign, and I've never recommend my clients doing this, they can sign these stipulations and give them to the landlord to hold what like an escrow and say, oh, if this happens, you can file my stipulation that I'm evicted. And I as the landlord am the person who makes that determination. Okay, I never, ever would recommend that. It's like, I want a hearing guy. Okay. I'm a big I'm like, you know what? I want a hearing on anything and everything because that's how you get to the truth.
Yeah, I think it seems to be a common trend, particularly among legislators, that when they pass a law, they envision the person they think this law will apply to. And that person is destitute, incapable of a job, incapable of a family, whatever. And so, unless you actually meet the people that are affected, which when you're talking about disabilities, that could be anyone. At any point in time, something may happen, and now you've got a disability. And so they envision the person, and the reality is you meet people, they have kids, they have jobs, they have cars, they have pets that are very meaningful to their lives. They have relationships, whatever it is. And I understand that the state really believing they have to exercise that authority for safety or whatever, saying we need to be able to detain people sometimes. I understand that argument, but 5 days, 10 days, 15, whatever it is, you really need to ask yourself, what if that was you? What have you been taken away from?
Yeah, no, in fact, what I think I might even I think I had this because in during the hearings for the PAMI Act, that was one of the quotes that was used about like, what if this was you? What if this was, your family member? What if this was, so that was really highlighted. And this is one of the, Senator Weicker was the one, and when the PAMI Act was passed, the reason it came to with mental health was he did a investigation into the mental health facilities. And I think he had some staff who were undercover actually go in, and this is one of my favorite quotes that he has. He says, the 3 days of these hearings will focus on those who have been left in the backwaters of our conscience. And so he was a super advocate for this. And one of the things I really this is like probably my favorite quote. Favorite's awful, but I mean about like what he had said on his floor speech on April of '85, is that we have seen the interests of tranquility and secrecy require that the voices within these walls be muffled and the truth is told be related in whispers between agonized family members and isolated advocates. In this climate, the clear, insistent demands of the Constitution and federal statutes exist as little more than rumors of hope. And so I thought that always gets to me because people always say, like, what are you doing? You're doing this, you're messing up things, you're gonna do that and that. I'm like, hey, my job is to protect and advocate for people's constitutional federal rights. I mean, if your truck was being taken away, you'd be the first to scream the law was being violated. I'm advocating for somebody whose law is being violated, and you're telling me that I'm creating a problem? That kind of irritates me, as you can see in a certain level. But
So recently there was some reporting of a proposed budget in HHS related that suggested maybe they might be cutting funding to PNAs. And for me, the reaction was a lot of fear because Protection and Advocacy Organization and grants like PAMI, they are the thing that exists for me. When you talk about rumors of hope, when you're in a facility, you are desperately grasping at a law that should apply. You're desperately hoping that someone is paying enough attention that this process is going to be meaningful and they're going to notice you. So if had an opportunity to talk to someone who is pondering PNA funding, and they were thinking, do we need to keep funding PNAs? What would you say to that person? Why do protection and advocacy organizations need to be funded?
well, I would go back and have them look at. There's a great interview with Lowell Weicker about the PAMI, and go back to the hearing and the testimony, and I have a number of quotes from these hearings. What I would say is this, is that if you get rid of the PAMI program, we're going back to that. Okay. So yeah, this was 1985. One of the things is oh yeah, so this is what it started with, that he had asked the Justice Department. Here's the excerpt from the Senate report. He had asked the Justice Department, like, if they knew of someone who was going to be dead or something like that, like what they would do. They had said, well, we'd have to go through this report, it'd take a couple of days. And he says that response from this official caused me to start this process. He says, because that's just insufficient. Oh, here it is. This is it. The Justice says, he says, this is the response from the Justice Department official. I think that if you know in advance that somebody's going to, your situation is you know in advance that someone is going to snuff out a life in the next hour, I would, and there was a 30-second pause. I'm not sure what, I'd have to look into that and whether the federal government is in position to go into advance of that. And so that caused Senator Weicker to say something's got to be done, and that's what kind of that's what's caused the report. And I can send you the report. The report that his staff did is just like, here's something from the report. Violence is considered a de facto feature of ward life in many facilities. Physical abuse of patients and residents in some state facilities for the mentally disabled is a shocking reality. It's like while facilities seek to maintain control, they frequently fail to maintain the basic amenities expected as part of their custodial function. What I would say, get rid of PAMI. We're all going back to that, because now instead of me meeting people who've been there 20, 15, 16 years, and I'm not seeing that anymore. What I'm now trying to do is like get the services for the person, so when they get out, they have a house, they have their medication, they have their whatever they need, that through Medicaid or whatever. And so it's shifted. You get rid of someone to help with those sorts of things. I mean, and our grants are not that large, but we do a lot of stuff. And I would just recommend anyone who's thinking about like PAMI being defunded or lower funded, just go back and read these reports from 1985.
Well, Mark, thank you so much for talking with me. Yeah, send me those reports and I can include the links in the show notes.
Sure, great. All right, thanks, Jesse.